All right, the dog's out of the room now. So I'm asking for $900. Well, not why 900? Well, you'll see why when you get to my declaration. Basically, that's the amount of time I had to spend at my hourly rate to prepare the motion and attend the hearing and all that type of stuff. Now, at the last paragraph, it will have what the motion is based on. Well, it'll be based upon this notice of motion, the memorandum of points and authorities that we'll talk about in a minute, my declaration, which we'll talk about later, and on oral and other documentary evidence that I may have to bring up at the motion. Okay, so lets the court know what I'm basing my motion on. Okay, and then we have a signature block for the attorney. Okay, in any document, we're pretty much going to have a signature block. And so that pretty much covers the notice of motion. Okay, so let's move on to the points and authorities. Okay, the memorandum of points and authorities, I put on a separate page with a separate heading. Some of your attorneys might actually request that you do a separate document for this with a separate bird cage. Okay, so we'd have a bird cage for the notice, we'd have a bird cage for the memorandum of points and authorities and the declaration. So ask your attorney how he wants it done. There's no really rule that we have to have a separate bird cage, separate document for each part of the motion. Generally, the shorter ones, we'll just kind of throw it all together like I've done in this one. Okay, so let's talk about the memorandum of points and authorities. Okay, this is where we're going to have our argument and our law on why the judge should do what we want. Okay, now the one resource that I absolutely have to tell you about that is absolutely indispensable to drafting motions in California is a resource called California Points and Authorities. Okay, I've already told you about California Pleading and Practice and what a great resource that is for drafting pleadings. Okay, Matthew Bender, which is the same company, also does the same thing for points and authorities. Okay, and what points and authorities are is I have a particular motion that's been written in the past or is pretty common. I can go to California Points and Authorities, pull the book off the shelf, and they'll have pretty much all the law that I need for my motion. Okay, now on Monday or Tuesday, I will have actual samples from California Points and Authorities to show you and that you will use in drafting the motion that you're going to draft yourself. Okay, so you'll actually get to see what they look like. The library's closed today, it's Sunday, and I'll get there tomorrow, and I'll probably get it up by Tuesday to help you draft your motion, which will be the last written assignment of the course. Okay, but let's just go ahead and look at this. As you notice, it's on pleading paper. Okay, normally we'll start with an introduction. Okay, the introduction tells the judge why we're here. Okay, why am I wasting his time? Okay, so let's look at that. Okay, this case concerns a dispute about real property that's up in Lockwood Valley, which is actually kind of out of the Fraser Park area. I had a client that had a land dispute with one of their neighbors. Okay, so that tells the judge what kind of generally the case is about. It lets him know that I sent form interrogatories, that I sent a request for production of documents. Okay, now is the judge going to just believe that? No. Okay, we have to have evidence that that actually happened. So what is my evidence? If you look on line 8, 9, and 10 of this particular page, which is what, page 3 of the motion, you'll see in parentheses Declaration of J. Jamison, paragraph 2, and Exhibit A, incorporated by reference herein. What that means is we're going to look at my declaration. In paragraph 2, it says what I just said above here. And Exhibit A is actually a copy of the demand for inspection of documents that I previously sent, and a copy of the form interrogatories that I previously sent. Now, why do I need that attached? Okay, because attached to those actual documents themselves, the form interrogatories and the request for production of documents, there's a proof of service. that was signed by my secretary. And it says, under penalty of perjury, my secretary dropped these in the mail on this date, and they had 30 days to respond, and they didn't. Okay, that's why that's important. We have to have evidence. Okay, the judge just isn't going to believe me. Okay, he knows me better than that, or she knows me better than that, right? Okay, they're just not going to believe me. Okay, so, and I also put, if you look at paragraph 2 there, beginning on line 11, despite the fact that I granted them an extension of time, okay, which is very common, okay, normally what happens is this. You know, the other side, they get busy, or their client isn't responding, and so they call you up and they say, hey, I need more time to respond. 99% of the time, I'm going to say, okay, how much time do you need? Okay, and so I will grant them an extension. By the way, your attorney should be granting them extensions, not you as the paralegal. Okay, I granted them an extension of time, usually, 15, 30 days. So the attorney will call me up and say, hey, I need some more time. I say, fine, send me a confirming letter, let me know that, and then I give them more time. The time passes, and sure enough, I didn't get my responses. That's why I had to file the motion, right? And so despite the fact that I granted them an extension of time, I haven't received any responses. Well, how does the judge know I didn't receive responses? It's in my declaration, which I signed under penalty of perjury. I generally don't like to perjure myself in front of judges. I don't think I ever have, but who knows? Generally, judges are going to believe me if I sign something under penalty of perjury. Okay, so here we are. Here's what the case is about. Here's the discovery I propounded. Gave them more time. They didn't respond, and judge, that's why it's here. Okay, all right, so that's the introduction. Now let's go into the argument and authorities. Okay, and this stuff right here is pulled straight out of California pleading, or California Points and Authorities. Okay, they have literally probably 15, 20 different authorities. Authorities are the law. Okay, they're either cases or statutes that support our argument. Okay, so let's look at this. Paragraph 1. If a party whom interrogatory fails to serve a timely response, the other side, the other party, can go before a court and get an order to compel them to respond. Okay, now, the judge isn't, does the judge know that? Hell, he went to law school. He knows. Okay, everybody knows that. But it doesn't matter. I still have to put the law in there so the judge, if he wants to, can go look it up. Okay, so what is my authority? Well, it's Code of Civil Procedure Section 2030K. Okay, so that's right there in the motion. Normally we put that in parentheses. I'm not going to get into the particular format of citation and stuff like that. That's better left for legal research and writing 1. But that's generally how we do it. Okay, let's look at the second paragraph there, beginning on line 22. When a party who fails to serve a response for production of documents doesn't respond, we can move for an order. Okay, so there's law saying if you don't respond to interrogatories, you can move for an order. If the other side doesn't respond to a request for production of documents, you can move for an order compelling a response. Okay, so that's the second paragraph there, and there's the law, Code of Civil Procedure Section 2031, parentheses M, subsection M. Okay, now paragraph 3. To the extent authorized by the Code of Civil Procedure, the court, after notice and an opportunity for hearing, may impose sanctions against anyone who's engaged in a misuse of the discovery process. Now, here is my law to say that I can get my sanctions. Okay, I'm alleging they engaged in a misuse of the discovery process. Well, what is a misuse of the discovery process? Well, that lets you know that a failure, if you look at the last sentence there in lines 3, 4, and 5, failing to respond is considered a misuse of the discovery process. Okay, so now I have my law for my sanctions. Okay, now, if a monetary sanction is authorized, unless the court finds it's unjust to impose sanctions, they must do so. Okay, where's my law for that? Well, Code of Civil Procedure Section 2023 and Ganui versus Super Shuttle. That's a case from 1993. Now, where can the judge find that? Well, if he looks in the California Appellate Reporter Series 4th, he can go to volume 20, page 256. That's the page it begins on. And if he looks on pages 260 to 261, he will find exactly what I said there. Okay. Now, normally you don't have to go word for word. You can summarize that stuff. But that lets the court know that unless they can provide substantial justification for not responding, I should get my sanctions. Okay. So let's go on to the next paragraph here. Let me put on my glasses. It's a little dark in here. Imposing a monetary sanctions. What can I get for monetary sanctions? I'm beginning on page 4, line 13. The court may order the attorney subject to the sanction to pay reasonable expenses, including attorney's fees incurred by their conduct. Okay, their conduct meaning failing to respond. Okay, the value of attorney services is a matter which the judge must necessarily be familiar. Okay, which means the judge knows how much time it takes to file a motion. He knows what a reasonable attorney's fee is, and so that gives him the authority to figure whether $900 in this case is reasonable. Okay, when the court is informed, its own experience provides every element necessary to fix their value. Okay, now where do I get that from? Well, Bacon versus Bacon. Okay, I don't think that involved Kevin Bacon, but you know, don't think he was alive in 1948 when that case was decided. Okay, sanctions should be imposed. Now, that's the law. All of those paragraphs are the law. Now, here is my argument. Sanctions should be imposed against the defendant and his attorney on the basis that they engaged in a misuse of the discovery process. Why? They failed to answer my questions and they failed to produce the documents that I wanted to look at. Okay. As a result, I've been put to the task of having to file this motion. Okay. Thereby incurring attorney's fees. My rate back then, by the way, was really cheap. I wasn't normally $125 an hour, but I did a lot of work on this case, so I gave him a little discounted rate. I think my rate was about $150 back then. Okay. So $150, $125 an hour, and it took me 5 hours to prepare the motion, or well, 6 hours. I'm sorry, 6 hours. And here I break it down. Preparation of the motion, 1 hour. Okay, now you might think that that is a little bit a small amount of time. Okay, the reality is I crank these motions out all the time. And after you've done a bunch of them, you already have a huge bank full of motions, and it really doesn't take me that much time. And lets the judge know I'm being reasonable. Hey, it took me an hour to draft this. You know, if you had to do this, it would probably take you all day. Okay, but with practice, you know, things become easier. Okay, so preparation of the motion, 1 hour. And then what's the rest of it? Well, I had to drive all the way to Ventura, hear the motion, and drive back. Okay, I'm going to charge my client for that time, so I'm sure as heck going to make them pay for it, not my client. Okay, so this is 5 hours of time to drive to Ventura and back and hear the motion. Okay, because you never know. You know, I always add a little bit more there because you know maybe it only takes an hour and 45 minutes to get to the Ventura courthouse. You know, a lot of times you're waiting around and your motion might not be heard until 6th, 7th, 8th, 9th, 20th motion and things like that. Okay, so where's the evidence for that? My declaration, paragraph 5. Okay, and then we're going to have a conclusion. Okay, what's the conclusion? As a result of the foregoing, what do I want? This is where I tell the judge what I want again. Okay, I want an order compelling them to respond. And if they don't respond again, then I can move for even more sanctions, like actually terminating the case and getting a judgment. And I want $900. Okay, and then I have a signature block. Okay, so that's a very, very common motion. Okay, motion to compel. Okay, there's literally hundreds of motions you can make. Okay, motion to change venue, motion to judge disqualified, motions in limine. I mean, there's literally hundreds. So I can, you know, we can't get into them all here, but this is the most common one, and this is